Welcome, Mr. Attorney General. Last June, your predecessor, then Attorney General Sessions, announced that the department would no longer defend the Affordable Care Act's pre-existing conditions provisions because they were inseparable from the ACA's individual mandate. 2 weeks ago, your department went much further, deciding that it would not defend any provisions of the ACA. This puts at risk other important provisions in addition to protection for people with pre-existing conditions, such as the Medicaid expansion, dependent coverage for young adults up to age 26, and coverage for preventive services. Now, the individual mandate is a highly regressive penalty, and I've long opposed it, and Congress repealed it. But I disagree strongly with the department's decision not to defend the rest of the ACA. In a letter that I wrote to your predecessor last June and to you on April 1st, I made the point that the individual mandate can be struck down and severed from the ACA while the remainder of the law can stay in place. And this isn't just my opinion. In 2010, the Chief Justice Roberts said in the Free Enterprise Fund case that under the doctrine of severability, that generally speaking, when confronting a constitutional flaw, we try to limit the solution to the problem, severing any problematic portions while leaving the remainder intact. In 1990, when you were head of the department's Office of Legal Counsel under President George Herbert Walker Bush, you authored an opinion finding that the president could enforce the remainder of the statute after an unconstitutional provision had been severed. I agree wholeheartedly with your 1990 opinion. What led you to take a different approach?
Thank you, Senator. When I visited with you before my confirmation, I promised you that I would personally take a look at this issue, and I did. And I studied it carefully, and I provided my views robustly within the deliberative process that was going on within the executive branch. As I've said, when the Attorney General is providing legal advice, I think the first obligation is to provide the advice that you think is the right legal answer and how you would decide the case if you were a judge, which is what was the advice I gave. But I also have said that if the other stakeholders in the executive branch and the people involved, the agencies and so forth, end up in a different place, as litigator for the United States, the Attorney General should be able to advance positions that he believes are defensible and reasonable legal positions, even if they are not positions that the Attorney General would adopt if the Attorney General was the judge deciding the case. In this situation, the ultimate decision was to support the position of the states, including Texas, and the decision of the district court judge. The rationale for that is that it is a defensible and reasonable legal position, given that that was the decision of the district court and the position of 4 justices on the original NFIB case who felt that if the mandate goes, the rest of the statute goes. I know there's an additional point there, which is the fact that Congress did take out the penalty from the mandate, and therefore should that act be viewed as essentially validating the rest of the statute. And those issues were debated, but at the end of the day, I felt that the position was a defensible position, and it was the decision of the executive branch.
I would just make the final point that Congress had the opportunity to strike other provisions and chose not to.
Yes.
Thank you, Mr. Chairman.
Thank you.